Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3003, United States of America versus Julien Richardson, appellant. Mr. Kaplan for the appellant, Mr. Burney for the appellate.
Good morning, counsel. Mr. Kaplan, please proceed when you're ready.
Thank you. If it pleases the court, my name is Matthew B. Kaplan. I represent appellant Julien Richardson. Your Honors, in our view, there's two principal issues in this case. Firstly, whether the sentencing guidelines were properly applied. Secondly, whether procedurally this court can reach that issue. The government contends that it cannot reach the issue whether the guidelines were properly applied because of the waiver that my client executed prior to his plea. In our view, that waiver does not bar this appeal, and that's for two independent reasons. Firstly, the court cannot find on this record that Mr. Richardson knowingly, intelligently, and voluntarily waived his appellate rights. And that is so because the district court not only didn't discuss the plea waiver with him, but it affirmatively misrepresented what was in the plea waiver. Specifically, the district court indicated that Mr. Richardson was giving up his appellate rights because of the fact that he was pleading guilty. Whereas, of course, that was not accurate. He was giving up certain appellate rights because he had agreed to in his appeal agreement, in his plea agreement. But that's not what he would have understood, and this court's precedent indicates that a defendant is entitled to rely on a reasonable understanding of what the trial judge tells him during the sentencing process.
But there was no misleading here, was there?
Well, respectfully, Your Honor, I think there was, because I think that the trial judge told Mr. Richardson that as a result of your pleading guilty, you're giving up all these appellate rights. But in fact, it wasn't because he was pleading guilty, it was because he had entered into a plea agreement. He could have simply pled guilty and not have given up those rights.
I'm not quite understanding how that prejudiced your client, the advice that was given by the court, because how is it, even if we take the assumption that what one would naturally construe from the court's statements was that the waiver came about by result of the guilty plea as opposed to the appeal waiver, how did that end up prejudicing your client?
Well, Your Honor, it misstates a material prong of the plea agreement. I think specifically the prejudice would be he had a choice. He could have gone before the court and he could have gone to trial, or he could have simply pled and retained his appellate rights. And, that was a decision he was entitled to make, and he was unable to make it because he didn't, as far as the record shows, he didn't understand what the plea agreement was.
Why didn't what the court told him explain the relevant part of the plea agreement? She went into the waiver in the portion you observed in your brief, didn't you?
I don't think, Your Honor, it explained. I mean, it didn't. The trial court did not explain at all. Didn't mention the existence of the appellate waiver in the plea agreement. And what it said is, I think it said quite clearly, is because you're pleading guilty, you're giving up these appellate rights. And I think the a reasonable defendant would have understood that anyone who pleads guilty gives up these appellate rights, and that was not the case at all.
So what you're saying is we should strike the plea?
I'm sorry, Your Honor?
So we should strike the plea, send it back to start over?
No, Your Honor. I think what this court has done in a number of cases is when it's found the defect in the plea agreement, it doesn't vacate the plea, but it remands for resentencing under the proper terms of the.
Well, you were saying that he's prejudiced by not having had the chance to plead straight up, I guess. I'm not sure why what she said wasn't adequate because she's playing his guilty plea, but even assuming it's not, I'm still a bit confused as to how he could have been prejudiced by not being told as part of the plea agreement when he had signed the plea agreement that had it in it and had counsel and heard this advice in court. It's a little hard to follow, counsel.
Oh, Your Honor, I think the point is simply that you're right. There is a written plea agreement, but the case law and the precedent says it matters a lot. You can't just look at the plea agreement. You've got to look also at what happened in the plea hearing and what the trial judge said. One other thing I'd like to just mention briefly is, aside from this waiver issue, the plea agreement issue, it's also in our view not enforceable because it's the result of ineffective assistance. Counsel didn't point out to the trial court how.
I'm not sure again what exactly it is counsel didn't do. I mean, the date on which your client claims to have ceased criminal activity was actually discussed in court. It wasn't just there, but what do you say counsel didn't do?
Well, principally, Your Honor, what we say counsel didn't do is the money laundering guidelines are clear. You don't look at the laws, as that term is normally defined in the sentencing guidelines. You look at the amount of funds laundered. And I mean, that's what it says. And there's a case law that says that what it says is what it means. But the trial court and the pre-sentencing report, all in the government, all seem to think that the relevant issue is the loss, as that term is broadly defined in the sentencing guidelines, is what matters. And in our view, trial counsel have an obligation to actually read the sentencing guidelines and see that's not what it says. It says you look at the amount of money laundered. If you look at the amount of money laundered, you would see that that total amount, what was actually laundered, was less than $550,000, which is a break point in the sentencing guidelines.
Am I right, counsel? And on that issue, the only decisions that specifically address frozen funds go against your argument on the reading of the guideline?
I think that's correct, Your Honor, but those are all decisions prior to the clarification of the sentencing guidelines. And I think there are newer decisions to say that the guidelines mean what they say. You look at the amount of money laundered. And just briefly, I point out what happened here is, there were two separate schemes. One was the fraud scheme. As a result of the fraud scheme, fraudsters overseas had money deposited into the account controlled by my client. But my client didn't put the money in it. And as to the $95,000, which would bring that amount over the $550,000, he didn't do anything with that money. He never laundered it. To do money laundering, you've got to do some type of financial transaction. And my client didn't do that. Financial transactions he did were funds that total, were with respect to funds that total less than $550,000. If there are no more questions, I'll reserve the remainder of my time for
Okay, thank you, Mr. Kaplan. We'll hear from the government now, Mr. Burney.
Thank you. May it please the court, Kevin Burney for the United States. I'd like to discuss the waiver issue first because that that was the bulk of the time that appellant's counsel spent on and was asked about. So first, the waiver here is enforceable. And it's already been pointed out that Mr. Richardson signed the agreement. He's well educated. He's completed 2 years of college. He dated and initialed each page of the agreement. And of course, Lee and Jackson has made clear, this court's precedent, that we look at the entire record as to whether a waiver is knowing, intelligent, and voluntary. But just on this point, in terms of this issue that the trial court misrepresented the plea waiver, which I think is appellant's main argument. So what the trial court said, and this is JA 18, is that, so do you understand that by pleading guilty, you are not only giving up your right to a trial, but you're giving up your right to appeal. And you're not allowed to say I was improperly convicted. And then the court says, the only basis that you can appeal is if I sentence you to more than the law would permit me to sentence you to, or if your lawyer was ineffective in connection with your sentencing. So the trial court has essentially laid out two exceptions for Mr. Richardson. And both of those exceptions are in the plea waiver. The plea waiver, this is JA 46, essentially says that Mr. Richardson is waiving his right to appeal the sentence, except the extent that the court sentences him to above the statutory maximum. The trial court explicitly mentioned that one, or guidelines range determined by the court. The court didn't mention that one, but of course he was not sentenced above the guidelines range. He was ultimately sentenced below the guidelines range. And then the last exception that the plea waiver mentions is that he can appeal on the basis of ineffective assistance of counsel, but not to raise other issues. And again, the trial court essentially stated that as well. The trial court said that he could appeal on the basis of ineffective assistance of counsel in connection with his sentencing. And that's exactly what he's doing on appeal. He's saying that his counsel was ineffective in connection with his sentencing. So I don't think there's any prejudice at all here. And of course, we need to look at Federal Rule of Criminal Procedure 11H to decide if there's harmless error. We would contend that there is harmless error. It's true that the trial judge did not go over the plea waiver explicitly with Mr. Richardson. But the rights that she outlined are the rights contained in the plea waiver. They're the same rights that he's trying to vindicate on appeal. And so he really hasn't suffered any prejudice in this situation. But of course, the government also recognizes that there's still the ineffectiveness assistance of counsel issue out there. So he hasn't waived that. And I'd like to discuss that a little bit.
Back up just a minute. Are you conceding that the sentencing guidelines issue is before us? I thought the reason we're talking about the waiver is that that's not encompassed within terms of the waiver.
I think it's before the courts in a different way than appellant wants it to be in front of the court. I think appellant essentially wants it to be in front of the court in two different ways. First, to say this court should reach the merits of whether the guidelines range was calculated.
And that depends on him winning the waiver argument, right?
That's correct, exactly. And our contention is that the court should not get to that issue.
Right, good.
But the court would still have to get to the issue in an indirect way because he's also alleging that his counsel was ineffective.
So again, we don't actually reach the sentencing issue unless we find that counsel was ineffective, right?
That's correct, Your Honor. Okay. And we would argue that counsel was not inefficient. And so appellant's counsel essentially has two arguments on that. The first is the guidelines issue, and that his defense counsel should have challenged the guidelines calculation. But the guidelines calculation was not wrong. It's true that you're not supposed to take into account the loss, but that is not what was taken into account here. The calculation that was used was the amount of laundered funds exactly as the guidelines requires. So I think it's useful to just go over the amounts very briefly. It's true that the loss is under $550,000. $550,000 is the threshold. It's true that the loss is below that. But the amount received into the money laundering accounts, the fraudulent accounts that were set up by appellant and his co-conspirator were over $600,000. And in fact, the trial court made that explicit finding. That's on JA 113. The court found that appellant and his co-conspirator were responsible for laundering over $600,000. So the only real dispute here is whether the $95,000 of frozen funds counts. And of course, we talked this at length in our brief, but it does. As the Chief Justice pointed out, the only two cases that have decided this issue have found that it counts. And I think appellant's counsel is trying to place a lot of emphasis on this amendment that happened in 2001, that somehow changed the ballgame. But it didn't change the ballgame with regards to this definition. Even though the definition moved from value of funds to value of laundered funds, there's nothing in those 2001 amendments that narrowed the definition that courts have been using beforehand. Nor did the Sentencing Commission express any disfavor towards Tansley or Thompson, these cases that I decided before. There's no evidence that that amendment, the motivation of that amendment was to change the way that courts had calculated the value of these funds, now laundered funds, that the trial court should use at sentencing.
Okay, Ms. Burney, can I ask you a question on just the standard that we're applying here? So for ineffective assistance purposes, under our decisions, in normal situations, we remand for resolution of an ineffective assistance claim, since in our court, we allow for them to be raised on direct appeal and remanded as opposed to being raised on collateral review as other courts do. But for our standard to determine whether to remand at all or whether just to reject the claim outright in the first instance in our court, it's the case that we only elect not to remand if there's not even a colorable claim on the performance prong. Is that right?
Well, I think this court typically does not remand when the evidence below suggests that a remand would be unnecessary. And here we would contend that there's no need for a remand.
I guess what I'm saying, I mean, I know at some point it's whether a remand is necessary, but the question is under what standard do we determine necessity? I don't understand us to be applying effectively in the first instance de novo standard to decide what the right answer is on the performance prong. It is that there's not even a colorable claim on performance. Now, sometimes we've said there's not a colorable claim, or we've said it's obvious that there's no prejudice. But I'm just, you've gone through the guidelines issue, and there was a lot of pages expended in the briefing on it. You're, of course, raised the point about the prior decisions exactly on frozen funds. I'm just trying to understand how much of an argument does the appellant need to have in order to at least just get a remand, not to win ultimately on ineffective assistance, but just to get a remand and get a chance to win in front of the district court. Is it right that as long as they show, as appellant shows, just a colorable argument on the issue, even if we think it's more likely than not a losing one, as long as it's a colorable one, do they get the benefit of a remand?
So the main case that I've looked at for that, Your Honor, is Sitzman. And Soto. And it says there, Soto, for instance, says, however, in some cases, the record is so clear that remand is unnecessary. Mm-hmm. And then in Sitzman, it's when the record clearly shows that the challenged attorney's actions were not deficient, or when the record clearly shows. But I think there needs to be a clear showing that Mr. Richardson was not prejudiced or that his client was not deficient. And we would argue that there is that clear showing here. The clear showing on why he wasn't deficient is because a lot of briefing has been spent on this issue, of course. And I see my time is running out, but I would just note that whether the funds are included are a very complex issue, which so far, again, the cases have gone the way that they are included. And so it would be I don't think counsel should be faulted for not anticipating this challenge in the law. The case law to this point has indicated that they should be included. On the prejudice point, Mr. Richardson got a sentence in the guidelines range that he wants. He wants a range of 36 to 46 months. He got 40 months. The trial court varied downward to make that happen. And the trial court went through a very detailed analysis in the sentencing. So this was a very thorough sentencing, which she made clear she was imposing this sentence aside from the guidelines. So even if trial counsel had spoken up, there's really no likelihood that it would have been different. And I see my time's about to run out or has run out, so I'm happy to answer any further questions. But if not, we would ask that this court enforce the waiver and otherwise affirm. Thank you.
Thank you, Mr. Burney. Mr. Kaplan, I think you had a little bit of time left. We'll round it up to 2 minutes for rebuttal.
Thank you, Your Honor. And I'll be brief. The key point I want to emphasize is in the sentencing guidelines, as they're revised, it refers to the value of the laundered funds. And in our view, that's perfectly clear. It means the value of the laundered funds. Now, there was some disagreement among the circuits prior to I think it was the 2001 change in sentencing. So it's possible the government's right. Maybe the purpose of that change was not to change the meaning, but to clarify the meaning, with the Sentencing Commission believing that some of the circuits had misinterpreted that language. But that's what the guidelines say, and that's what they mean. And in our view, trial counsel was clearly ineffective by not bringing that the language to the attention of the trial court. The government says that there's no prejudice because the client received the sentence he wanted. Of course, he didn't receive the sentence he wanted. He received the sentence that the court felt was appropriate. He wanted, in fact, I think his specific request was a home detention. And again, going back to the first issue that we discussed, whether the trial court's statement on the sentencing issue was misleading. It was misleading. It told, a reasonable understanding of what the trial court said is that you give up rights by pleading guilty. These are the rights you give up by pleading guilty. He
was giving up the rights by pleading guilty. He was. It is also true that pleading guilty involved a waiver. But by pleading guilty, if he had not entered that plea that day, he wouldn't have given up those rights, would he?
I'm sorry, Your Honor.
If he had not entered that plea that day, he would not have waived those rights. He did plead and he waived the rights. I have difficulty following why that's misleading.
Your Honor, I think the argument is that he didn't give up those rights by the act of pleading guilty. He gave up those rights because he opted to enter into a plea agreement.
Right. Right. And that was the circumstance that existed that day. And he knew it. And the court knew it. And the court spoke consistently with it. And I'm just really not finding a lot to sympathize with here, counsel. I don't see the misleading element.
I think it's just that he did not understand that he had the right to plead guilty and retain. There's no evidence that he knew that he had the right to plead guilty and retain his appellate rights. But, as we've discussed, even setting aside that particular waiver argument, we think we should prevail in effective assistance. Counsel.
Thank you.
Thank you.
Okay. Thank you, counsel. I want to make sure my colleagues don't have additional questions for you.
No.
Thank you, counsel. Thank you to both counsel. Mr. Kaplan, you were represented by the court to assist the appellant in this matter, and the court thanks you for your assistance. We'll take this case under submission.
Case number 22-1002, In Re National Nurses United et al. Petitioners. Ms. Darrow for the petitioners, Mr. Gilliland for the respondents.
Morning, Council. Ms. Darrow, please proceed when you're ready.
Good morning, and may it please the court. 650 Americans died of COVID-19 yesterday, and a similar number will likely die today. Although no federal agency has a complete count of healthcare worker infections and deaths, the incomplete numbers that we do have are staggering. Since the beginning of the pandemic, more than 1 million nurses and other healthcare workers have become infected with COVID-19, and more than 4,100 have died. According to data provided by CMS, in January and February of 2022, just after OSHA announced that it was rescinding the emergency temporary standard at issue in this case, 18% of all nursing home workers became infected with COVID-19 in just those 2 months alone. The daily rate of death is higher now than it was in June of 2021, when OSHA found that the emergency temporary standard was necessary. At that time, as OSHA noted in the preamble to the ETS, the rate of death was about 500 per day. COVID-19 is, as OSHA said in its brief in this case, an unprecedented crisis. OSHA has also said that the impact of the pandemic has been borne disproportionately by nurses and healthcare workers who are called to care for those who become infected. Yet OSHA has left those very workers without necessary protections in violation of its clear statutory duty. When Congress passed the OSH Act in 1970, it had the foresight to equip the agency with both the tools and the mandate to act quickly to protect workers in an emergency situation like the one we face today. The statute—
Ms. Darrow, as a practical matter, is the current ETS still in effect, in your view? And how is that actually being implemented on the ground? Because it hasn't been formally withdrawn.
Correct, and thank you for that question. On December 27th, OSHA announced in a public statement published on its website, and which is included as Exhibit 1 to our petition, that it was withdrawing the emergency temporary standard. It has never walked back that position, aside from in a footnote in its brief to this court. And in OSHA, Secretary Parker has also announced that the agency has a non-enforcement policy with respect to the emergency temporary standard. In our experience on the ground, my union represents registered nurses who work primarily in acute care hospitals. And when nurses have made complaints to OSHA, which they have continued to do, specifically 2 complaints were made in February by nurses at hospitals in Florida, both owned by the same healthcare corporation. They complained to OSHA that their employer had not notified employees of a COVID exposure in the workplace and other violations of the ETS, and they were told by field agents specifically that the ETS had expired and that they were no longer enforcing it and would not inspect it. So as a practical matter, the December announcement that it was being rescinded, the public statement by the secretary that of a non-enforcement policy, and then apparent instructions to field agents that the ETS has expired and shouldn't be enforced. The practical effect of all of that is that healthcare workers lack the necessary protections that OSHA itself found were required to protect them.
The meat of your complaint before us, or your petition before us, is that the agency has not gone forward with the permanent regulation by the date suggested by Congress. Is that a correct statement?
Our complaint about the agency's conduct has two components. One is that it is treating the emergency temporary standard as rescinded, which is a violation of Section 6C2, and also that it did not issue a permanent standard within the 6-month timeline that is required under Section 6C3.
That's the one that I'm troubled about your case on that. We had a case not involving anything parallel to this, but tangentially, back in 1988, there was a NRDC brought an action against Odell for not meeting a congressional schedule. And then Judge Ruth Ginsburg at the time wrote that where Congress has put a timeline like that into statute without specifying a remedy, Congress did not intend to subject it to judicial scrutiny, and that there would not be within the compass of the court to enforce that deadline. Isn't that, in that sense, at least parallel to this case? It's the NRDC versus Odell.
In this case, the clear statutory text is that OSHA has a 6-month timeline for issuing a permanent standard. The purpose of that is to require that OSHA act quickly and expedite its proceedings.
Yeah, in Odell, it was a reporting requirement and not a rulemaking, so it is distinguishable, but it was a reporting requirement that Congress imposed on the agency, and it clearly had passed. Reporting deadline, it clearly had passed, and is a unanimous opinion written by then Judge Ruth Bader Ginsburg to the effect that when Congress puts that limitation in there, time limit, does not specify a judicial remedy, that is a matter between the political branches and not something that can be remedied by the court.
I'd also like to add that OSHA's own regulations interpret that portion of the statute as mandatory. The regulations provide that OSHA must expedite its own proceedings in order to meet the 6-month timeline, which it views as required. And
now, you know, you're asking an extraordinary remedy in mandamus, and it is supposed to be that you are clearly entitled to the relief before we can mandamus. Are you clearly entitled to this relief here?
I believe so. I do understand that it is an extraordinary remedy, and I think that this is an extraordinary situation. The OSHA itself, again, in the preamble to the ETS, estimated that the multi-layered approach that the ETS requires in healthcare settings will save about 776 lives and prevent 300,000 infections of healthcare workers in a 6-month time period. So the loss of life in this case that is attributed to OSHA's non-action is quite extraordinary. The statute is unambiguous. OSHA has not provided this court with any sort of statement that the court may defer to, except for in the ETS itself, in which OSHA says that it will remain in effect until it's superseded by a permanent standard. And the ETS itself contains no expiration date on its own terms. So we believe the extraordinary remedy is warranted here.
Ms. Darrow, while the circumstances of the pandemic are certainly extraordinary, we still have to find that there's a clear duty for OSHA to act in an expedited manner here. And so where does that clear duty come from? I think that's difficult here because the secretary can promulgate an emergency temporary standard, and then the statute requires moving forward with a permanent standard, within 6 months. But in the process of 655B, the secretary can always determine that a permanent standard is no longer necessary, right? It's not clear from the statute that they must promulgate a permanent standard. They could do an emergency standard, and then the secretary could conclude within the secretary's discretion that such a permanent standard was not necessary. So if that's the case, then where's the clear duty for OSHA to do this permanent standard?
The secretary could conclude that, but in this case has not. The secretary made a finding that that healthcare workers face a grave danger, that the provisions of the ETS are necessary for workers, and that finding has never been withdrawn or rescinded in any way. OSHA has never made a statement. It has never reached the end of the 6B process and concluded that the standard is necessary.
So even if it is necessary, then why, I mean, the OSHA has represented, the Department of Labor has represented that they're going to finish the permanent standard within, I don't know, I think they said 6 to 9 months. Why is that insufficient? Or why is there a clear duty that they have to do so faster? I mean, they're suggesting that it's impossible for them to do it faster.
So the combination of the non-enforcement of the ETS in this interim period and their failure to issue a permanent standard within 6 months has created a temporal gap of an indefinite period of time during which healthcare workers who face a grave danger at work lack necessary. And the statute doesn't contemplate that gap. It contemplates continuous protection for the workers who need it most in an emergency situation.
What would our mandamus look like? What would we be specifically mandating the agency to do?
Thank you. What we seek is an order from this court that OSHA give full effect to the emergency temporary standard until it is superseded by a permanent standard, and also that you know, if the ETS remains in effect in this interim period, the sense of urgency for the permanent standard is somewhat abated, but OSHA should be directed to adhere to its own timeline that it has proposed to this court or suggested to this court is feasible, and that's 6 to 9 months from when they filed the brief. They have not been, they are required by their own regulations to expedite the process, and in this case, they've let significant amounts of time go by from the time that they proposed the rule in the form of an emergency temporary.
So far as the effectiveness, continued effectiveness of the emergency measure, the legal record before us is that it is still in effect, isn't it? Is that not the case?
That is not the case. The OSHA has not said that in its briefing to this court. It made the public announcement in December, and then it has been acting in accordance with that public announcement that the ETS is withdrawn. And
so can I ask you, Ms. Darrow, if we thought, suppose that the conclusion is made, and we'll ask the government about it, obviously, when they stand up, but that the emergency temporary standard is still in effect. If it's still in effect, then the relief you're asking for, and put aside the timeline for the promulgation of a permanent rule, just focusing on the ETS for now, the relief that you're asking for, if the ETS is still in effect, is that then the government has to enforce it? Is that the gap that remains if the ETS is in fact in effect?
If this court holds that the ETS is in effect, then OSHA, of course, still has some prosecutorial discretion in order, to determine in an individual case whether to prosecute or not. But it cannot maintain a blanket wholesale non-enforcement.
It can't?
It cannot.
What authority do you have for that?
I have a couple of cases. I think this concept was best expressed in the OSHA context in a district court case in this circuit. And
surely you don't think this court could order OSHA to enforce its regulation?
This court can order OSHA to give full effect to its regulation, and enforcement is one piece of that. There are other components, important components.
I'm not sure where we would get the jurisdiction to do that. We have jurisdiction to review orders and judgments of agencies, but as far as the general execution of the law, that's, I don't know of a statute that gives us jurisdiction to do that.
Sure. What we're asking the court to do again is to give full effect to the emergency temporary standard, and that includes things in addition to enforcement, which I'd like to address if I have the opportunity. I'd also like to mention that the emergency temporary standard required states that have their own state OSHA plan to implement a standard that's equal to or better than the emergency temporary standard. Since December, many states that have their own state plan, including large states like Virginia and North Carolina, have withdrawn those state plans entirely and officially, leaving those workers completely unprotected. So if the ETS is ordered to be in effect, those, regardless of OSHA's enforcement, those states will be required to have an ETS that is greater, that is equal to or better. And the importance of a uniform national standard is something that OSHA addressed in the emergency temporary standard. There were business groups who complained about there being a patchwork system that was impossible and or burdensome to comply with in terms of COVID regulations in the workplace, and they asked for a national standard for that reason.
Sarah, those may or may not all be good policy reasons for OSHA to move forward, but we still have to, as a court, have jurisdiction over this matter. And as Judge Sentelle mentioned, you know, there's the Hodel case. There are, there's sort of a general background presumption that the executive branch needs to have the ability to organize its priorities, right? And this statute explicitly allows the secretary to set priorities. In light of all of that, I'd like you to say a little bit more about where there's a clear duty for OSHA to do this, a duty that gives us as a court jurisdiction to order OSHA to take one of the actions that you're pressing for.
Sure. So it's true that OSHA does have discretion to organize its own priorities, and that discretion emanates from Section 6G of the Act. What 6G says is that OSHA must prioritize workplaces and industries where workers face the most urgent need for protection. And OSHA has determined that that is healthcare workers right now during the pandemic. So even exercising its 6G discretion, OSHA must prioritize these workers.
Well, OSHA is now saying, that is a priority, but they're saying there are other higher priorities, right?
They have not said that. They said in the emergency temporary standard that healthcare workers face a disproportionate burden of the pandemic, and they have never made any statement to the contrary.
Well, they suggested that the vaccine ETS was of higher priority, and so they spent resources pushing that out quickly. And they said now they're going to turn back to this ETS.
They did say in their brief that the vaccine ETS took precedent for a short period of time, which but the reality of that timeline is that that was issued in November following a September order by the administration that they implement such a standard. So there was a 2-month period where they were working on that standard. It was struck down by the Supreme Court in January, and OSHA has, and there's no evidence that they were expediting that proceeding, either in the issuance of the ETS or setting it for permanent rulemaking. Since January, that rule has not been in effect. And OSHA, just by way of example for their slow action in this case, the emergency temporary standard was issued in June. Normally, they'll set a hearing at the same time they announce a proposed rule or shortly thereafter. They didn't announce a hearing in this matter until a couple of weeks ago, and they set the hearing for April. A hearing was requested back in August. They didn't set it then. So they've let a lot of time go by and are not expediting the proceeding as they're required to, both under the statute and under their own.
Okay, Ms. Dara, let me make sure my colleagues don't have additional questions for you at this time.
No.
Okay, then why don't we'll give you some time for rebuttal, and we'll hear from the government now. Mr. Gilliland.
Morning, Your Honors, and may it please the Court. COVID-19 pandemic has required the Secretary to make difficult choices.
Could you speak up just a little more, please, Counsel?
Pandemic has required the Secretary to make difficult choices regarding the allocation OSHA's limited resources. That has included delaying the healthcare final rule in lieu of a separate ETS that was equally or more urgent. Those decisions by the Secretary have been rational in the context of the statute. They've been based on legitimate statutory concerns, and they've been taken in good faith.
Can I ask you at the outset, what is the government's position on whether the emergency temporary standard is still in effect?
The emergency temporary standard has not been withdrawn in the sense that it is still on the books of the CF.
Oh wait,
So,
I didn't quite. Can you speak directly into the mic? Sorry, I'm having a little trouble hearing you. But
Closer to you.
Yeah.
The ETS is still in effect in the sense that it is on the books in the CFR. Ms. Darrow correctly described the position that that OSHA has taken, that the December 27th announcement effectively announced a non-enforcement policy, and the Secretary, as OSHA said it would, has been proceeding through enforcement and investigations of the General Duty Clause and the other.
So let me ask. Can I just stop you there? So the government thinks the ETS is still in effect, and the December 27th. So that the government must believe then that it didn't expire by operation of law, by operation of the statute after 6 months, right? Because that would have happened on December 21st.
That's correct, Your Honor. Let me address the withdrawal specifically. No,
but
has
before you address the withdrawal, just the lapse of the 6 month would have preceded the withdrawal, right? Because that would have happened on December 21st.
yes,
So I assume by virtue of the fact that the government on December 27th felt like it needed to say something about the ETS, then the government must believe that the ETS didn't expire on December 21st.
correct, Your Honor. The Secretary's position is not that the ETS automatically expires at 6 months. At the time that OSHA made the announcement on the 27th, OSHA expected that the rulemaking to finalize the healthcare rule was going to take many, many months. Best case scenario, there would have been 6 to 9 months to finalize the vaccination and testing ETS, and then there would have been best case scenario another 6 to 9 months to finalize the healthcare rule. So, given dicta in many cases that have sort of either assumed that an ETS expires at 6 months or treated it as having a maximum duration. The Secretary believes that Section 6G allows some extension in the rulemaking. The Secretary also believes that there's some reasonable amount of time that the agency can continue enforcing the ETS. But with the extended period of time, whatever the outer bounds of that reasonable leeway is, the Secretary believes it would exceed those bounds with its projection of how long that rulemaking is.
So I'm sorry, is it the Secretary's position that the ETS does expire at 6 months or within some short period after 6 months, or just that it's unclear whether it expires after 6 months?
Secretary's position is that it does not expire at 6 months because the Secretary has discretion to extend the rulemaking. The enforcement doesn't expire at 6 months, but it is enforcement of ETS is an extraordinary remedy for OSHA, and so OSHA believes there would be an unreasonable amount of time for which the Secretary could continue enforcing. And believe
I'm not sure I've ever heard a yes or no as to whether OSHA's position is that the ETS is in effect now. Just give me a yes or no. Is it in effect?
And it is not being enforced now.
It is not.
No, but is it in effect? Sorry, Judge Sentelle. I just want to follow up on Judge Sentelle's question. Is it in effect? I know that you're saying that it's not being enforced, and that gets to the question of enforcement discretion. And Judge Sentelle, if I've misinterpreted your question, I'm interested in the same answer. And I just want to get an answer to not the enforcement question, but whether the emergency temporary standard is still in effect. I think that's what we're all asking for an answer to.
Yes.
Because that's important, right? Because obviously OSHA could begin enforcing something that it had previously decided not to enforce.
Correct. And OSHA, on the 27th, when OSHA announced that it would be withdrawing. The plan was to issue a Federal Register notice withdrawing, in which case it would not be in effect. In light of this litigation, the fact that it was filed on an emergency basis, the agency decided not to go forward with issuing a Federal Register notice to remove the ETS from the Code of Federal Regulations in the event that this court then, ordered the Secretary to continue enforcing, in which case the Secretary would have to issue another Federal Register notice. It would cause a lot of confusion with the regulated community. It could cause enforcement issues.
What is your argument based on the statutory text that an ETS can continue in effect for 6 months if there's no superseding regulation?
Well, as the petitioners point out, the text of the statute does say that an emergency temporary standard continues until superseded by that standard.
There has to be a standard promulgated in accordance with the procedures prescribed in paragraph 3, right, C3. And so now that you're past promulgating something within 6 months, does that mean that you have not promulgated a standard within the procedures prescribed by C3, and therefore the ETS lapses?
OSHA has not promulgated a permanent standard pursuant to the 6B procedures.
Right, they haven't done it pursuant to the C3, right, which requires following subsection B and promulgating a standard within 6 months, a permanent standard within 6 months.
Correct. Your Honor, the Secretary views that 6-month period to be the same as the other timelines in 6B that this court in the El Congreso cases determined based on 6G weren't etched in stone, that the Secretary has discretion to exceed those. So I don't think that to say that the Secretary hasn't finalized the standard in 6 months, I don't think that necessarily.
So even if I agree with you that the Secretary has more than 6 months to finalize a standard, that doesn't go to the question about whether the emergency temporary standard lapses if you fail to promulgate a permanent standard within 6 months. Right? Because those are two different questions. I mean, maybe you need to maybe the agency has some discretion to take a longer time for a permanent standard. But C2 suggests that failure to do that, perhaps it suggests this, I'm interested in your argument about this, means that the emergency temporary standard simply lapses.
I think reading the provision in the context of the section of 6C that says that it will continue until superseded by a standard would allow the Secretary to continue enforcing for a limited period of time after. And then that extension could be challenged under the track factors, just as this case is. In that case, the interests prejudiced by the delay would be the employer who is forced to continue complying. So it wouldn't be an unlimited amount of time. And that's
when you say it wouldn't be an unlimited amount of time, are you saying it wouldn't be an unlimited amount of time because an action could be brought like this one that would require, in response to which a court would require something to happen? Or suppose there's never any action. Suppose nobody ever brings a lawsuit. Is there something in the statute that, in your view, means that the emergency temporary standard goes past 6 months, but then lapses after some, I think you called it a reasonable period after 6 months? Where's that? Why wouldn't it just continue?
Well, there is nothing I can point to in the statute that would require it to expire, but I believe it would operate in the same way that 6B standards operate, the Secretary's discretion in that area where employers can come to the court and say you have unreasonably delayed. And they've done so in the court as in the Octor case, UAW v. Donovan. That's how those cases have operated, that the Secretary had discretion and at some point abused that discretion by delaying too long. And I think that would be the same principle
Can I ask a follow-up question to Judge Rao's question about whether the ETS authority lapses automatically after 6 months? And I just want to make sure I understand the government's position on this. If it were true, I'm asking you to argue against yourself in a way, but bear with me for just a second. If it were true that the ETS lapses after 6 months, because at that point, a permanent standard couldn't be adopted in accordance with C3. I think that's the question that Judge Rao puts to you, and I have the same question. Then would it follow from that then any permanent standard that came after 6 months also wouldn't be promulgated pursuant to C3? So you could never have a permanent standard either once you get past 6 months. In other words, do they go together?
No, Your Honor, because issuing the emergency temporary standard serves as a proposal, which then triggers the normal 6B processes. So the government's view is that then the ETS itself would just be treated as an NPRM, notice of proposed rulemaking, and then the normal rules would apply in terms of the timeline and being able to bring that to a final.
So then what's the limit on the secretary's ability to just do everything through emergency temporary standards? If you can do something as an emergency temporary standards, not following Section B, not following the requirements of the APA, and that standard continues, for some reasonable period of time, perhaps indefinitely, that doesn't seem consistent with the scheme that Congress enacted. The emergency temporary standard is an exception, right? It's an exception to the ordinary procedures. It's and Congress explicitly says it's for 6 months, right? So it is temporary. So I'm not sure how the government can interpret it quite this way.
The limit to what OSHA can issue as an emergency temporary standard is in the high bar that it has to meet in order to issue it in the first place. The finding of grave danger and the finding that the ETS is necessary to address that grave danger, which is a higher standard than the secretary has to meet in a normal rulemaking. So I think once the secretary makes that finding, it is reasonable to think that Congress intended that extraordinary situation to be addressed for at least a reasonable amount.
Is there anything that precludes the secretary from issuing one ETS, and then if say we assume that lapses after 6 months by virtue of the statute, could the secretary then immediately enact a subsequent ETS for another 6 months, along the same terms, finding there's still a grave danger, we do this emergency? Could the secretary keep doing that? Would that be consistent with the statute? Is there anything that prevents that from happening?
The Florida peach growers case from the Fifth Circuit found that the secretary could make changes to or issue subsequent ETS on this, I forget the exact language, but under the same terms as he could issue an original. So I think in that scenario, if the secretary were to reaffirm a grave danger finding and that it was still necessary, then the secretary could reissue or revise the ETS. Again, still subject to a challenge from employer.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Gellin. Then we'll thank you for your argument, and we'll give Ms. Darrow 2 minutes for your rebuttal.
Thank you. I'd first like to address the question from two of the judges about jurisdiction to order OSHA to expedite this standard. And this court has before in Public Citizen Health Research Group, the OCTR, that's 702 F2nd 1150. found that under 6G, it could order OSHA to put a particular standard at the top of its list of priorities and ordered expedited rulemaking towards that standard. Next, on this question of whether a blanket non-enforcement policy is an exercise of prosecutorial discretion, the case that I was referring to earlier, the district court case, which applies OSHA in particular, applies this concept to OSHA in particular, finding that OSHA announced that it was no longer going to accept forms that it previously required, and that this amounted to not simply an exercise in its discretion to not enforce a rule, but the suspension of the requirements entirely, which the court found was outside of prosecutorial discretion. In this circuit, a similar concept, but under the Merchant Marine Act, is found in the case Crowley Caribbean Transportation v. PINA. I'll provide the site if you're interested. And the court distinguished between an unreviewable decision to forego enforcement in a particular case versus a reviewable statement of general policy of non-enforcement. And here, I think we've heard, it's undisputed that OSHA has a policy of non-enforcement, which is not.
Are you bringing that statement of non-enforcement, if it is in fact a formal adoption of position, are you bringing that for review here? Your petition to the court, petition for mandamus, did not petition for review of the order, did it?
The announcement of a blanket policy of non-enforcement was made in February after the briefing was completed in this case, and we are not bringing, seeking review.
Right, so that's not before us.
Correct.
All that's left seems to be before us a general policy is being followed, and I don't know what our jurisdiction is. You know, we had a case a few years ago concerning some oil and gas wells where we had that same situation. We agreed that perhaps the agency was following the policy, but we didn't have an order before us to review, and we had no jurisdiction. So I'm not sure if we can review an announcement that wasn't even made at the time the petition was filed here.
The announcement was also made in December 27th, which is before this court, that it was withdrawing the ETS without any statement of reasons why, which is required under Section 6E of the Act. I'd also just like to point out that OSHA has never before allowed an ETS to lapse after 6 months, even though it has issued emergency temporary standards that have continued in effect while the permanent rulemaking procedure continued, taking longer than 6 months. And those cases are detailed in our brief. And to get to your question about what's to stop the Secretary from using his emergency powers to issue and reissue to get around 6B rulemaking, I agree with what counsel said, which is that the standard is higher. There must be a finding of a grave danger, and that the provisions are necessary to prohibit that grave danger. What we're arguing in this case is that OSHA must expedite its permanent rulemaking so that that situation does not arise. We don't want the emergency temporary standard to be out there indefinitely. We want a permanent standard to be issued expeditiously in accordance with the statute, with the regulations, and with the prior case law of this circuit. If the Secretary were to determine that the ETS should be modified in some way or extended, it can be modified. It could be reissued, and the Secretary would have to, again, state its reasons for doing so as required under 6E. And in this case, there has been no 6E statement other than in the emergency temporary standard itself and its preamble, which establishes that the emergency temporary standard is necessary to prevent a grave danger.
Let me make sure my colleagues don't have additional questions for you, Ms. Darrow, at this time.
Nothing further.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Thursday, April 7th.